Hi, I'm Keith Grossman. I am an attorney, mediator, and educator at law. I'm here to talk to you today about my mediation process, which I called Think Outside the Court. And I'm going to run through how that process works and how that process is able to help you. If you are interested in contacting me after you learn more about this and you want to work with me, you can go to my online calendar, which you'll find through pshark.com, and schedule a 15-minute phone appointment with me. So let's go ahead and talk about the process of mediation. So as I said, the first part is that we're going to have a 15-minute phone consultation. Now, this is going to be a discussion that's not going to be legal advice or anything like that. I'm simply going to explain to you how the mediation process works and how I handle the process through my office, which I'm going to talk about in this video as well, so some of this will be a refresher for you when we have that phone call. Now, I can have a 15-minute phone call with you and your spouse together if you would like to do that. Again, as I said, there will not be any legal advice. We're just going to be talking about the process. So if you want to schedule a 15-minute phone consultation separately or together, either way is fine. Through that phone call, we're going to learn about the mediation process, how the process works, what my role is as a mediator, what services I provide, and we're going to talk about how I schedule the mediation sessions through my office. The costs are very easy, so I typically charge a flat fee for a mediation where you are having the mediation with me before filing for divorce in court, and there are not attorneys involved, at least at the beginning. And so I charge a flat fee of $3,000. That fee is shared equally by you and your spouse. That covers 8 hours of time. And if we go beyond the 8 hours of time, then I charge my regular hourly rate, which is $400. So $400 per hour, also shared equally by both of you. So those would be the costs. What do I need from you and your spouse? I need you to contact me and have the conversation, obviously, so I can explain these things to you. And then I also can tell you what the next steps are. And so if you tell me that you're ready to move forward, we'll take care of you paying the retainer, we'll take care of you signing the retainer agreement, and I will provide you by email with the documents that you will need in order to get started in the mediation process with me, and we can start scheduling the appointments that we will schedule. So that's what we'll go over in the phone call, and then that would be the next steps after the phone call is over. So how do we move through this process? Well, we have 3 steps. The process of getting ready to mediate, or the stage of getting ready to mediate, then the stage of working towards an agreement of the terms. So we're looking for a complete resolution of everything. So we're going to talk about terms for that purpose. And then after we have reached those terms that resolve everything, the 3rd stage is writing up that final agreement. So you'll have it in writing. So let me talk about all of these stages in more detail, and I will go ahead and start with the get ready to mediate part. So after we have the 15-minute phone consultation and you have retained me so that we can go ahead and get started, I will provide you with some things to start thinking about and looking over. So I have a workbook that you can review. I will send you the Florida Supreme Court form for your financial affidavits. Financial affidavits are something under Florida law that it's required for you to complete and share with each other. And you'll each do your own individual financial affidavits. I'll explain that a little bit more to you, and you will have an opportunity to revise that a few times after we've had some conversations and those sort of things. But I'll provide that to you so you can start the process of putting together your financial affidavits, which will contain information about your income, your expenses, your assets, and your liabilities. So that's one thing. If you have children, I will also provide you with a copy of the Florida Supreme Court form for a parenting plan, what we call a parenting plan. The parenting plan is where we will contain all of the information and the agreed upon terms related to your children. So what the parenting schedule will look like, where they will spend their overnights, what holidays will look like, what vacations will look like, how you will handle decision making, how you will handle discussing matters related to your children together. So all of those types of things will come under the parenting plan. And so I will share with you the Florida Supreme Court copy so that you can start reviewing that and maybe even discuss what you want the parenting arrangements to look like. We will discuss it. I will facilitate that discussion in mediation to whatever extent that is necessary, so that at the end of the process you will have a written parenting plan that is agreeable for both of you, as well as the written settlement agreement that will be addressing your property, will be addressing any debt that you have, will be addressing all the finances related to your children, and will address alimony. So those are the types of things that I will furnish you with for the purpose of getting ready to mediate. So after we are together and you have reviewed your marital assets and your debts for the purposes of our discussions, you have put together any of the financial documents that we may need to look at as part of the mediation process, I will be preparing you also for the mediation journey. And one of the ways I do that is I schedule, before we have joint sessions together in mediation, I will do 30-minute individual sessions with each of you. Those 30-minute individual sessions allow me to make sure that I understand all of your goals. So what do you want the finish line to look like at the end of the mediation process? We'll also have an opportunity for me to make sure that I'm dialed in on whatever your concerns are before we move into the mediation process and have sessions together. And then also it's an opportunity for you to let me know if there's any particularly sensitive topic, some kind of hot button sensitive topic. It's an opportunity for us to have a little bit of a discussion around that before we all get together in the joint mediation session. So that's part of what I'm going to do to help you prepare for the mediation journey. And as I said, we're going to get a clear understanding of what your goals are and what your concerns are. Now, in terms of agreeing upon your terms, a lot of times my mediation clients come into mediation where they've already had discussions and there are things that they've already agreed upon. So the first thing that I want to be clear on is, what is it that you have agreed upon? And is there truly actually an agreement? Because sometimes there's a little bit of a misunderstanding, so I want to make sure that we're clear on that. And also, you may have agreed upon some things, but did not have a full discussion. Didn't realize you didn't have a full discussion because you're not experienced in these things. I've been doing this for over 30 years. You haven't. So I will make sure that some of the important questions, some of the important topics that you may not have thought about are being covered. So I will facilitate that discussion about what you've agreed upon, and then I will also facilitate the discussion about all the other things that need to be determined, need to be agreed upon in order to finalize your divorce. So we will talk about your settlement options. I will be able to brainstorm solutions with you. I'll tell you what your options are. I can't give you legal advice, but I can tell you what the black and white law says. So I can explain to you information. I can give you legal information, and then you have to decide what you want to do with that information, because I can't offer my opinion on that or give you advice on that. But we're looking to come up with settlement options that both of you are satisfied with. We're looking to do that with the parenting plan also. So not just that you're satisfied with, but that is for maximizing everything you want to have for your children. The time with your children and the guidance as co-parents together. So a healthy parenting plan for that purpose. We'll figure out how to divide up the marital property, figure out what those options are, what may work, what may not work, how are the finances impacted by those decisions. We'll go through all those things as part of the discussion. And then we'll also work out alimony and child support. Child support in Florida is based on a formula. So we will go through the formula, and we will take, I will, from you, take certain data that I'll plug into the formula, and then we'll see what that looks like for the bottom line of the child support amount. If there's some data that maybe we want to change, something that is a little bit unclear, and we want to see how certain things impact it, we can do that together and look at a few different child support calculations based on different data. Alimony in Florida does not have a formula like that, like I just explained. There are certain criteria, there are certain things that if the judge was making the decision, the judge would have to look at, and there are some boundaries, some guidelines as far as how alimony should be handled. So we'll go through those things and we'll discuss what kind of financial need there is and what type of ability to pay alimony there is. And we'll talk about those things and we'll look at those guidelines and what the Florida law says on alimony so that we can figure out what works best for the two of you as well. And so then the next part is to write the final agreement. So from our discussions and the information that I gather from you, I will start the process of writing the final agreement. And so after we have our first mediation session together, I'm usually able to put together a first draft. And then we'll have an additional mediation session. And at that second mediation session, I will provide you, usually a few days beforehand, a copy of the draft of that final agreement, that parenting plan, if that's appropriate. And then you'll have that to look over before we meet again. You'll have that in front of you when we're having our discussions, and we can add to it, we can modify it, we can have further discussion about anything that is in that agreement, anything that is in that parenting plan. So we'll start that process and work on that as we're moving through the mediation process. One thing I did not mention earlier is that I schedule the joint sessions in blocks of 2 hours of time. And usually I find that most families need 3 or 4 of those sessions, those joint sessions in blocks of 2 hours of time. So during the course of those sessions, which are usually about 2 weeks apart, we are able to start reviewing and revising and building upon the settlement agreement and the parenting plan. So each time that we meet, we're looking it over, we're discussing it, we're revising it, we're modifying it, whatever we need to do. So that process is happening, and then before we finalize the mediation agreement and the parenting plan, you will have an opportunity for each of you to review the final agreements with a mediation-friendly attorney, and these would be 2 separate attorneys, so you each would do that on your own, and be able to get any of that legal advice or any of the other things that I'm ethically prohibited from doing when I'm providing mediation services, since I'm not working for you as your attorney and I'm not giving you legal advice and I'm not advocating for either one of you. So there are certain things that having a mediation-friendly attorney review it with you would be potentially important to do. If you wanted to bring attorneys into the mediation process and have a little bit more of an active role, that's possible as well. That's something that we can discuss that will be tailored to what your needs are. But you also don't have to have an attorney. Florida law does not require you to have an attorney to represent you. So if I say to you that you can review this now with mediation-friendly attorneys and you say, we're good, we don't need that, that's fine. You're allowed to make that decision. But if you feel like you do want to review it with an attorney, then you have that opportunity. And I will provide you as well with a list of about 5 attorneys who I consider to be mediation-friendly attorneys. And you can choose any of them that you want to contact in order to have that consultation to review the agreement before we finalize it. But again, the choice is yours. If you're fine with how everything went in mediation and you're ready to go ahead and finalize it and sign it, perfect, we can do that. So through the mediation process, I will also gather all the other information that I need from you in order to assist you by drafting the other documents that you need in order to file for divorce in the Florida court system. I get the information from you. I use the forms that have been created by the Florida Supreme Court, but I will go ahead and talk about any of that information with you. I'll gather that. I will create those documents. And so at the end of the mediation process, in addition to the mediation settlement agreement, in addition to the parenting plan, you will also have all of the other documents ready to be able to take. Now, I will go ahead and share those with you. I will show them to you. I will explain them to you. I'll answer any questions you have about them. As the mediator, though, I'm ethically prohibited from filing all of these documents for you. So I also give you a checklist. So when you're ready to file, you can double check on the checklist, cross-reference, and make sure that you have all the documents that you need in order to go ahead and file. I'll give you the instructions on how to go ahead and file in court and how to do that, what that looks like. And then I will answer any other questions that you have related to the filing process. And then you will go ahead and you will take care of doing the filing of all of these documents. Once you have all of these documents filed, so my suggestion is that you just do this one time, you wait till you have everything that you need, and then you file. At that point, then you're just waiting for the judge to issue your final order, which is called a final judgment of dissolution of marriage, and that is the order that will adopt your agreements and will also legally announce that you are in fact divorced, so legally divorced. The final judgment of dissolution of marriage is the final order that does that. So once you have filed for the divorce decree and then you have just the period of time you're waiting for the judge to issue that final order, there's nothing else that you really need to do. But if you have any questions or anything, I'm here to answer them and to assist you with that as well, to whatever extent that I can. So just reviewing once again, we're going to start this mediation process off by getting ready to mediate. So that's going to start with your 15-minute phone call. That's going to start with the workbook I provide to you. That's going to start with the documents that I send you. And then we're going to move into agreeing upon your terms. I'm going to facilitate that discussion. I'm going to brainstorm solutions with you. I'm going to talk about different options that you have available to you. I'm going to share resources with you, which may be referring you to some other professionals like a forensic accountant, a financial advisor, a mental health professional. So whatever fits for your needs, we can talk about that and I can assist you with that for the purpose of trying to get everything resolved and agreeing upon all your terms. And then once we have accomplished that, we will get all those documents finalized, we'll finalize your agreement, and I will provide you with the information and the checklist so you can then go forward and file in court. So if you have other questions, I'm ready to talk with you in this 15-minute phone consultation that I explained about. The easiest way to do that is through my online calendar. You can access my online calendar through my website, pshark.com, and you just find some time that's available for you that I have available on my calendar. You'll select that and we will get that set up and we'll have that phone call. And as I said, you can do it individually or I can have the phone call with you and your spouse together. I look forward to talking with you. I look forward to being able to help you, and I wish you peace, love, and harmony.